Hello everyone, wanted to create a series of workers' comp videos and explain how the system works in Florida. So we're going to start with this video for my car vlog. You know, what to do when you first get injured in a workers' comp case in Florida. You know, what's supposed to happen both on the employer side and on the claimant side. So obviously, right after an injury happens, the most important thing is to obviously make a decision about, is the person going to get any medical care? You know, you can go to an urgent care, you can go to emergency room, but the important thing is just get seen by somebody. You know, you never know what's wrong with you until a doctor looks at you. And then, you know, then there's a reporting obligation on the part of the claimant to the employer. Depending on the type of accident, you know, most cases are supposed to be reported within 30 days. Some of them are a little bit longer, like repetitive trauma, for example. It's supposed to be reported within 30 days. And actually the statute actually says the injury has to get reported. It's not, and sometimes we quibble over if it's the accident versus the injury, but it does say the injury. And there's exceptions to that, obviously, if there is actual notice. You know, if you know, in the situations where the injured worker doesn't say anything, but the employer actually has, like, someone in management sees it, or it's a car accident, for example, and it gets reported and it's known. So there's exceptions to that. And then the employer has to fill out what's called it's a DWC-1, which is a notice of injury, and it has all the information on it, the claimant's information, the employer's information, insurance information, and then that brings us to, obviously, importantly, it's supposed to get reported to the insurance company if the employer has insurance. Some of them don't. So the insurance then gets involved. They may be the ones who actually send the person to the doctor, because the insurance company in Florida gets to decide who are the doctors. And then, you know, after the initial situation, then it becomes a question of, you know, can this injured person still continue working? Sometimes the answer is yes, sometimes the answer is no. And so there's a difference between temporary partial disability, temporary total disability. So totally disabled means person goes to doctor or hospital and they're put on what's called a no work restriction, which means they can't do any work. And if that's the case, obviously they can't come back to work. They're temporary totally disabled, and the insurance company might have to start paying you your checks, essentially sort of a reimbursement of your payroll. And it's paid like a paycheck every 2 weeks. It's not as much as your paycheck. But if you're not totally disabled, if you're what's called temporary partially disabled, then, you know, the employer has to make a decision if there's work available for you within your restrictions. For example, if you have, you know, no lifting, bending over 20 pounds, then, you know, there may be jobs you could do, for example, sedentary employment, which is mostly a desk job sitting. And that's sort of the general what's supposed to happen initially. Obviously, if you're on the injured worker side, if you're paying for anything, you want to keep receipts. If you have a visible injury, then taking photographs is a good idea. On the employer side, same thing. If there's a video of the accident, you want to save that. Or we should say a video of the lack thereof of an accident, right? If you have video of where the injury is supposed to have taken place and no injury took place, then that's obviously something that's good to have. And that's the initial sort of what's supposed to happen. Obviously, we get into a lot of other detail, and I hope to in a lot of some of these videos, but please like and subscribe if you'd like to hear more legal information for Florida. Thank you.